Let's sync back up. There we go. Sorry about that. I had a problem. My YouTube side was not active at all, so I had to go and pop that up. So hello YouTube. Sorry, there was an error in creating the stream through the OBS side, and it duplicated, and I guess I selected the wrong version for streaming, so that is my bad. I should probably go ahead and do this. I'm Jacob Davidson from Legal Layman, and I try to learn the law because I do not know the law. That's probably going to be my intro, I think. We'll figure it out. But anyway, sorry for not streaming yesterday. This is news for the YouTube side. I had meant to, but a chicken and rice diet apparently kicks your ass if you don't do it, if you're getting used to it and you're trying to manage your calories. I was dead. I wanted to die more yesterday than I did any other day. I also didn't go to sleep until like 8 a.m., which I normally try to be asleep by 6 a.m. for some consistent sleep schedule aspect, and it just didn't happen. With all that said, yeah, so there was that sleep issue, and I think I'll just move on to the topics. Still, sorry about not streaming yesterday. Hopefully we'll get into the topics for today, and it'll all be great. So the Ralph Yarl situation, I have only heard about. I've seen people starting to protest. I'm not very familiar with it, unfortunately, so we'll just have to figure it out as we go. SCOTUS is back on track to hear another abortion case. I have an opinion piece on it that may or may not be accurate. And Texas is having some fun. Texas news. There's a man who died and came back to life, apparently, as well as... What's it? There's a vaccination bill in Texas that certain healthcare providers do not like, I don't think. I forgot to list this topic, but that teen in Canada that basically, I think he got hate crimed for voicing an opinion against the trans agenda, is now filing a human rights violation or human rights complaint against Canada itself, I believe. And that'll be fun. That'd be great. Oh, I gotta steel myself. Apparently being a day away from this is detrimental. I did not realize how rough it is getting back even after a day of not doing this. I'm also getting rid of the hotkeys. That's why I started off on the camera and not my face like I normally do. Or I started on my camera in the face and not the stream start soon thing. Presenter. Okay. All right, let's get into the topic. Sorry for the delays. I'm hoping to cut that out pretty soon. Kansas City Star. So this is an opinion piece. I should probably come back to that after I finish reading this one. Kansas police probe shooting of black teen who went to the wrong house to pick up his younger brother. Talk about wrong place at a wrong time. Update: prosecutors have filed felony charges against the homeowner in the shooting. Read the latest here. The investigation into the shooting of Ralph Yarl, a black teenager who was shot by a homeowner after he went to the wrong house to pick up his brother, includes questions about whether race played a role. Authorities in Kansas, Missouri City said. Yarl remains hospitalized with serious injuries. There we go. Here's my live stream. Just making sure that it's up. Oh shit. Forgot to put away the code. My bad. I don't think I should leave that overlay on the screen for... Shrink it down a little bit, make it less prevalent. Alright, that'll probably be my setup from here on. And then I'll grow it back out to size whenever it's time to do the ad reads. An hour in, I've only got 52 minutes left. Damn, why is my YouTube side chugging? Oh, it's just my phone. Alright, well, that'll be fine. Yarl remains hospital, serious injuries. Attorney Ben Crump, who would have fucking thought? Ben Crump arrives when a black kid gets shot. Who's representing the family, said the homeowner initially shot the teen in the head and then shot him a second time after the boy fell to the ground. If that second part is true, then his whole defense falls apart. That's attempted murder. At least without very good reason. If he fell to the ground and didn't have a weapon aimed at the guy who shot him, and the guy shot him a second time, that's a bad deal. Police are quickly preparing evidence for prosecutors in Thursday's shooting, Chief Stacy Graves said Sunday at a news conference at police headquarters. I want everyone to know that I am listening, Graves said, and I understand the concerns we are receiving from the community. The Kansas City Star reported that the 16-year-old victim, identified only by family members as Yarl, was hospitalized Thursday night after he was shot while trying to pick up his younger twin brothers from a friend's house. Oh no. Shit, man. Police said he went to the wrong house and was shot there. Officials would not confirm the number of times the homeowner shot the victim or where his injuries were. Police initially said Yarl was stable but had life-threatening injuries. His current condition has not been released other than that he is stable. Police have not identified the shooter or his race, though Crump told the Star that based on what he told his family, it was told by the teen's family the shooter is white. It is inescapable not to acknowledge the racial dynamics at play, Crump said. Well, it's not escapable and not beneficial for you, Crump. You want the racial aspect because you can galvanize the people and start making more money that way. Crump is only in it for the black blood and black money. Information that officials have now does not point to race as a factor in shooting, according to Graves, but that remains under investigation. Investigators also will consider whether or not the suspect was protected by standard ground laws, Graves said. Yarl was meant to pick up his brothers from a friend's house on 115th Terrace or 115th Terrace. He ended up ringing the doorbell at a home on 115th Street. Faith Spoonmore, the teen's aunt, wrote online. The man opened the door, saw Yarl, and shot him in the head. When Yarl fell to the ground, the man shot him again. Yarl got up and ran from the property, but he had to ask 3 different homes before someone helped him, Spoonmore wrote. I guess the shot to the head was a grazing shot, so like it hit him and then he got hit somewhere else, either not so important that he couldn't run away. Police officers said they responded around 10 p.m. Graves said Sunday that the homeowner was taken into custody Thursday and placed on a 24-hour hold. While searching the scene for evidence, detective found the firearm used. Law enforcement released the suspect pending further investigation after consulting with Clay County's prosecutor's office. Clay County's prosecutor Zachary Thompson released a statement on Monday saying his office had not yet received criminal referral from the Kansas City Police Department regarding the case. We're actively working with law enforcement in an attempt to speed up that process, Thompson wrote. I wonder if that process gets sped up for normal people or if it just seems politically expedient. Missouri law allows a person to be held up to 24 hours for a felony investigation. At that point, the person must be released or arrested and formally charged. In order to arrest someone, law enforcement needs a formal victim statement, forensic evidence, and other information for a case file to be completed, Graves said. Do they need the formal victim statement, though? I don't think they do. Because of the teen's injuries, Graves said the police haven't been able to get a victim statement. Then I guess they can't file charges. Mayor Quentin Lucas, who attended it at the news conference and who attended the news conference, said police understand the community's concerns that the shooting could be racially motivated. Some members of the police department attended Sunday's protest in the neighborhood where the shooting took place to listen to community's concern. So they protested within the community, despite the guy maybe not being there. Crump told the Star on Sunday that the family has retained his Florida-based law firm. You can't just shoot people without having justification when somebody comes knocking on your door, and knocking on your door is not a justification. This guy should be charged. You cannot shoot people without having justification is a proper statement. I will give Crump that. That is a proper statement. And knocking on someone's door is not often a justification. That is also true. However, there are situations where someone knocking on a door can be justification to shoot somebody. There are situations where it's not. Of course, the statement was, the guy opened the door and saw Yarl and I guess got spooked. Crump has represented the families in seveal Trayvon Martin, Michael Brown, Ahmaud Arbery, Breonna Taylor, and George Floyd. Trayvon Martin is not his best case. Not a good case. Crump said the homeowner initially shot the teen in the... Oh wait, no, Tatiana Jefferson? Damn, I could have seen Ben Crump at the fucking... in Fort Worth, and I didn't. Why didn't this motherfucker do a Tatiana Jefferson? It would have been so fascinating to meet him. Crump said the homeowner initially shot the teen in the head, and then a second time after the boy fell to the ground. The family has also retained Lee Merritt, a Texas-based civil rights attorney who previously represented the family of Cameron Lamb, who was fatally shot by Kansas City Police Detective Eric DeValknery in 2019. Even though Yarl is doing well physically, he has a long road ahead mentally and emotionally. Spoonmore wrote in a GoFundMe she started to raise money for Yarl's medical bills and other expenses. Missouri State Representative Marlene Terry said that the Kansas City Police Department must work quickly to investigate this crime with full transparency. Once again, the state of Missouri has witnessed the shooting of an unarmed black male teenager, this time because he knocked on the wrong door while picking up his siblings. Bernice King, of course, he got a King commenting, "We need to work for the legislative and heart change to prevent these tragedies." What thing would have prevented this? Celebrities such as Halle Berry, Kerry Washington, Jennifer Hudson also posted messages on social media about the shooting. His name is Ralph. Oh my god, they're doing the his name thing. "I'm sick and tired of this feeling. My heart completely broke. Instead of waiting for Love is Blind, make a phone call for Ralph Yarl, demanded the prosecutors." Just a little bit of a, yeah. I will actually go ahead and display the GoFundMe for Ralph Yarl, because I don't think... It's not his fault he showed up at the wrong place and got shot. They've already met their goal. They're actually way past it. God, do I wish I had that money, though. Ralph is currently at home with family. He can ambulate and communicate. A true miracle considering what he survived. Each day is a different day. It's a .32 caliber that strong? I gotta figure out the facts of the case. Look, I don't doubt he's a great kid. But I'm also not so sure how everything went down is as it said. My God, heartbroken for this young man and his family, praying for his complete recovery. It seems like he has made a very strong recovery, so you know. That is good. That is very good, actually. I'm actually happy about that. No jokes, no crassness, no whatever. It's good that he recovered from this. I don't know much about the case, but I gotta look into it. So Ralph Yarl updates. Ralph Yarl. It's bad business getting shot while picking up your sibling. Wow, this is an event. Ralph Yarl shooting suspect Andrew Lester turns himself in to Kansas City police. The suspect in the shooting, Kansas City teenager Ralph Yarl, is in custody after handing himself in to the police a day after prosecutors filed charges against him. 84 Andrew Lester, 84, is accused of shooting 16-year-old in the head after he mistakenly rang the doorbell at the wrong home as he tried to collect his younger twin brothers. Andrew Lester, charged in the shooting of Yarl, has surrendered at our detention center and is in custody. He is in the booking process right now, Clay County Sheriff's Office said in a statement. Clay County Prosecutor Zachary Thompson confirmed in a press conference on Monday afternoon that there was a racial component in the case. So, as he announced, Mr. Lester had been charged with 2 felonies: assault in the first degree, which carries a punishment of 10 to 30 years or life imprisonment, and an armed criminal action, which carries a 3 to 15 years. Prosecutor have already set a $2,000 bond for Mr. Lester. Where is the racial element, though? What's their evidence on this? I want to see it already. Following the shooting, Mr. Lester was initially taken into custody, placed on a 24-hour hold. However, Missouri state law, a person can only be held for 24 hours. After the guy's photo, a 16-year-old high school junior was shot in the head and hand as he tried to collect his sibling. Police said teenager accidentally went to the home on 115th Street versus Terrace by mistake. According to the court documents, a witness told police that they saw a vehicle pull into Lester's driveway around 9:30 p.m. Mr. Lester told investigations that he had just laid down when the doorbell rang and he picked up his .32 pistol and opened the interior door of his house. He told the police he saw a black male pulling on the exterior door and thought he was trying to break into the property. Claimed he was scared to death at the boy's size and feared he was unable to defend himself given his elderly age, documents state. Lester said he fired twice and that no words were exchanged with the victims. During the informal police interview at Children's Mercy Hospital, the teenager said he did not pull the door, he was waiting outside. He told investigators that the man opened the door and immediately shot him, causing him to fall to the ground where he was shot for a second time. Ralph told police that the man said, "Don't come around here." Following the shooting, Ralph managed to stumble away to some other homes in the neighborhood to get help and was rushed to the hospital. On Monday, he was released from the hospital to recover at home from his injuries. So you have 2 competing narratives. And I do not think that the narrative favors Lester. I hope he has lived a full life because I don't think he's coming out of this without pain. yeah, it's entirely possible this kid is gonna get filthy rich off of this. Which, honestly, if I were shot in the head and the hand, I would also want to. But I also think this man's not gonna have a very good time after this. When Sean King doxes you or threatens to dox you, you know you're not in for a good time. When a white man goes after a white man. So that's the Ralph Yarl situation. It's pretty interesting. I'll need to find someone who has the ability to access court documents because I don't know all the facts as they are right now. But I do know at least that we've got the police, a statement from the person shot, and a statement from the defendant. Someone should probably make a statement that, you know, innocent until proven guilty is a standard in America. Oh. 58, okay. Mr. Lester told investigators that he had just laid down when he opened the door. I don't have a reason. Well, actually, I kind of do have. I can imagine a reason why Ralph could lie now. There is actually a reason why Ralph could lie about the situation. And there's also a reason why Lester could lie about the situation. However, with the presumption of innocence for Yarl, I think the best idea is to weigh everything in, or not Yarl, presumption of innocence for Lester. I think the appropriate idea is to see things in light of favor to Lester. But yeah, here's Ralph's GoFundMe. Created 2 days ago. Medical. Ralph deserves to have a future that he dreams about. He deserves to be the light that shows the world that love wins and that humanity is still good. But yeah, I don't know what change that one king mentioned. I don't know what change that entails. What's her name? What's her name? Bernice King. My goodness, let's be for justice, which is the continuum. That means that man who did this should be charged. It's a presumption, it's highly presumptive that justice means he should have been charged. And we need to work for the legislative and heart change to prevent these tragedies. So I guess these are the twins. This one's the older one. I just know it. This one's the older one. Yeah, What is the... How can you be sure? Justice in this case is filing charges. But if the man was well within his legal right, I am it's a little weird, honestly. In order to arrest someone, law enforcement needs a formal statement. I don't think they do need a formal statement. Apparently he's in jail on a $2,000 bond. Quit your racism. Sorry. So yeah, that's that topic. I'm going to probably just check that notification real quick. It's Camelot. It's Camelot. Fiscal political views usually are determined by how. Yep. It was Camelot. So, on to the next topic. Always fun. I come back to this every time. It's an opinion piece, I believe. The justices were kidding themselves. The Supreme Court takes up abortion after saying lawmakers should decide. They didn't take up abortion. I gotta accuse Politico of their falsehood here. Hold on, hold on. Politico. He's openly proudly committed to helping people with Crow use wealth to exercise power. That's not a Thomas problem, it's a problem to court and contemporary American rights. Oh, whatever. What about George Soros, huh? House Republicans were the most vocal opposing Kevin McCarthy. Of course they were. Rather, yeah, here it is. Abortion not legal nationally now due to the Supreme Court. Didn't you read the ruling? Whatever. Abortion's not back, you fucking idiots. size to arbitrary and capricious reasons from the FDA and a history of harm to women. There we go. Yeah, I'll send that. I don't care. The issue probably comes down to whether or not the Fifth Circuit has the jurisdiction or capacity to block the FDA's relaxed standards. Oh fuck, man! I got a craving suddenly. The court is expected to rule by Wednesday on whether to allow an earlier decision from the Fifth Circuit Court of Appeals to take effect, sharply limiting access to commonly used abortion pill nationwide. It should be said that it doesn't limit access to it. It just makes it's a common sense abortion restriction. If it's not safe, you limit it. You restrict it. Abortion is back before the Supreme Court just 10 months after a conservative justice said they were washing their hands of the issue. The court is expected to rule on Wednesday whether to allow an earlier decision from the Fifth Circuit Court of Appeals to take effect, sharply limiting, lowering a court ruling, which the Biden administration wants paused while the legal battle plays out, would prohibit telemedicine prescription, mail delivery, and retail pharmacy dispensing of the drug. Maybe they could enforce the Comstock Act there, you know? It would also narrow the window of time patients are authorized to take Mifepristone from 10 to 7 weeks of pregnancy before many people know they are pregnant, and cut off access to the generic version of the pill, which are used in roughly 2/3 of medication abortions. The case now before the court undercuts one of the core arguments justices made when they overturned Roe v. Wade in June. That it's not appropriate for unelected members of this court to override the democratic process and set national abortion policy. If they hear it, they could just affirm their decision. Like, they could just go and say, hey, yeah. Well, there's two problems here. The abortion pill is not a ruling on abortions utterly. And two, it's not a ruling on abortion, it's a ruling on the FDA. So this pill was approved under the FDA under Subpart H. And it is a rare drug that is approved because... Hold on. Yeesh. Because the medications that were approved under Subpart H that allowed this one to go through is the same kind of subpart that allows cancer research drugs to go through. Other life-threatening conditions like AIDS and HIV. This court will no longer decide the fundamental question of whether abortion must be allowed throughout the United States through 6 weeks. 6 weeks, 12 weeks, 15 weeks, or 24 weeks, or some other line, declared Justice Barrett. Barrett, Kavanaugh, and concurring opinion in Dobbs. Instead, those difficult moral and policy questions will be decided as the Constitution dictates by the people and their elected representatives through the constitutional process of a democratic self-government. While the issue currently before the court is a technical one that hinges on judicial and administrative processes and not on the merit of the party's abortion rights argument, it still have to have the kind of substantive national impact that justices vowed in the Dobbs ruling to avoid. Because the topic is mildly adjacent to it, doesn't make it substantively so. Politico has a slant here, and it's clear to see, and it's in their interest to paint it this way. Because if you can pressure the judges into saying, yeah, the FDA can make whatever drug they want viable, and this one drug that does a portion of the abortion, yeah, it's this is an abortion issue now, not an FDA's administrative discretion issue. The justices were kidding themselves if they thought the decision in Dobbs would somehow get them out of the business of dealing with abortion cases, said Stefan Vladek, a constitutional lawyer, professor at the University of Texas School of Law. One would have remarkable blinders on not to have seen that. The abortion pills dispute is just one of several cases around the right to terminate a pregnancy that could ultimately come before the Supreme Court. Issues ranging from whether states' anti-abortion laws clash with federal protections for patients, to the religious rights of people who support abortion access, to concerns over limitations to the Title X family planning programs, are already working their way through the lower courts. Once Dobbs comes down, it was predictable that this would happen. You're not going to get the federal courts out of abortion, said Carl Tobias, the Williams Chair in the University of Richmond School of Law. Society will continue to fight about this. There just isn't a middle ground. In a Friday order, Justice Samuel Alito, who authored the majority opinion to overturn Roe, put on hold the restrictions on abortion pills that were set to take effect in most of the country, argued and agreed to consider pleas for emergency relief from the Biden administration and the drugs manufacturer. The anti-abortion medical group that brought the challenge have until noon on Tuesday to submit arguments to the court, pushing for the pills restriction to take hold, while arguments on the case move forward at the Texas District Court, which first decided to suspend the FDA's approval of Mifepristone, and the Fifth Circuit, which upheld the party ruling that Texas Supreme Court vote this week to freeze the abortion pill restriction indefinitely while the case unfolds in the lower courts, or to allow them to go forward for now. Though the Fifth Circuit's order now sits before the Supreme Court, wouldn't go as far as Texas District Court Judge Matthew Kacsmaryk, who ruled in early April to cut off access to the pills nationwide. It would roll back access to abortion pills for millions, including those in Democratic-led states that have voted to protect abortion rights. This is probably I mentioned on the Comstock Act portion. It is time to heed the Constitution and return the issue of abortion to the people's elected representatives, Alito wrote in Dobbs less than a year ago. The permissibility of abortion and limitations upon it are to be resolved, like most important questions in a democracy, by citizens trying to persuade one another and then voting. That is what the Constitution and the rule of law demand. Legal experts say the sweeping pledges to leave the abortion fray once Roe was overturned were doomed from the start. Anti-abortion advocacy groups have been transparent that they see toppling Roe as just the beginning and striving for the prohibition of abortion nationwide, using whatever levers of power are available, from legislation to lawsuits to corporate pressure campaigns. Well, at least they don't call it reproductive rights. At the very least, they don't call it that. So they have my thumbs up on that statement. The rights of fragile unborn children cannot simply be left to the states, the group SBA Pro-Life America wrote in a memo to Congress shortly after the Dobbs ruling. According to our estimates, blue states that support abortion rights account for approximately 50% of the abortions taking place nationwide. That's fine. It's their state. They can rule on it. Vladek argues that the Supreme Court's declaration last year failed to account for two things: how much federal regulation is already involved in the abortion space, and how aggressive anti-abortion advocates would be in pushing further. Armed by the court's acquiescence in Dobbs, or correction in Dobbs, it's a court's correction in Dobbs, the justices either underappreciated or failed to account for how ready the anti-abortion movement was. Even if the abortion pill case had not jumped to the top of the justices' to-do list, several other federal cases concerning abortion rights could land on the Supreme Court's docket. Those include legal battles over whether providers in the Title X family planning program can refer patients for abortion, whether state abortion bans violate federal laws requiring hospitals to treat patients in life-threatening crisis, and whether states' ban violates the religious rights of people whose faith supports abortion access. More than a dozen Democrat attorney generals are challenging the remaining federal restrictions on abortion pills, in case likely headed to the Ninth Circuit Court of Appeals, and courts in West Virginia and North Carolina are currently hearing a pair of cases that test whether the state or federal rules around the pills should govern whether, how, and when patients can receive them. The FDA is a federal administration. What is the FDA? FDA in executive. The Department of Health and Human Services, which includes the FDA, is an executive branch. The executive branch implements and enforces laws that Congress enacts, sometimes issuing regulations to do so. No one elected the FDA. So these federal regulations that are in place, they could be safely overturned. It wouldn't damage the democratic process. Still more cases could be on the horizon as legislatures pass abortion laws that reach across states and advocacy groups prepare more legal challenges. That is a problem, those abortion laws that reach across states. That is an actual problem. Supreme Court justices were always going to have to resolve conflicts and tensions between state and federal law. After overturning Roe and said University of Michigan law, I don't trust any Michigan people right now. Leah Littman, especially now that states are going after abortion in ways that step on others' rights, including the right to travel. Yet Stephen Adden, the chief legal officer and general counsel for anti-abortion group Americans United for Life, argues that justices are semi-retired when it comes to abortion, and the Dobbs decision reduced the number of cases headed their way. I don't think SCOTUS can avoid the issue on the whole forever, he said. But there's been a sea change. Litigation has shifted almost exclusively now to the states, so in that way, the Supreme Court's got its wish. You don't have dozens of federal cases trying to punch their ticket to the dance anymore. Adden, who is representing 147 conservative members of Congress in an amicus brief to the Supreme Court this week, pushing the justice to allow the abortion pill restriction to move forward, argued that doing so squares reasonably well with the Dobbs ruling, even if it has the effect of dictating abortion access nationwide. I don't think the Supreme Court can fully divest itself of this issue because of the federal agency action, he said. Nobody can be arbitrary or capricious, including the FDA. In its emergency petition to the Supreme Court last week, Denko, the manufacturer of the brand name version of Mifepristone, quoted that the conservatives' words from Dobbs, arguing that allowing the lower court's limits on the abortion pills would violate what Alito Kavanaugh and others wrote about the proper role of the courts when it comes to abortion. The argument is not whether it comes to abortion, it's about whether it comes to the FDA's ability to make rules and to administer some drugs. That's the problem. The argument that the side that wants this pill to go forward makes the wrong argument. The courts announced in Dobbs that it was returning the issue of the abortion to the political branches. The company's attorney wrote, if the courts deny a stay, it abandons the assurance, allowing the Fifth Circuit opinion to stand, eviscerates the sovereign authority of the states that wish to expand and protect access to medication abortion in their jurisdiction. Yet the Biden administration made no mention of Dobbs in its appeal to the court, focusing instead attacking the challenger's case and arguing that the harm caused by allowing the pill's restriction to take effect far outweighs any harm caused by maintaining status quo. Legal experts see this as the most prudent approach, arguing that it could backfire if it looks like the Justice Department is accusing the court of hypocrisy. Particularly in a case where the administration thinks they have a chance of getting 5 votes, they aren't going to be throwing punches and picking fights, Lippman said. Brett Kavanaugh and John Roberts think of themselves as principled institutionalists. They don't like being called out. Even if that were the case, the argument that it's an abortion argument is wrong. It's a pill that happens to do abortions. However, if this FDA regulations were applied to, I don't know, a cancer pill, it would not be so harshly fought over because people would think, oh wow, there's probably a very good reason why the courts are deciding that this cancer or HIV pill is being taken off the market or having restrictions placed on it. The courts must have a very good reason. However, in this case, the slightest argument against abortion pills is seen as wrong and evil and tantamount to bullshit, I guess. I don't know what I was going to say there. Ruling on this issue, either in favor or against it, isn't an opinion on abortion. In no way. It's simply just a ruling on the FDA. If the FDA wants to hide behind bullshit and say, oh, but we're protecting abortion, I guess that's on them. And hopefully they have a better argument next time. I really do hope they do have a better argument next time. Would be nice. Because this argument is unconvincing. It's an abortion thing. Oh my god, my abortion rights. But like, anyone can see it's not that. If they would read the Fifth Circuit ruling, they would see clearly that the justice there decided that decision not on the abortion argument, though he is an anti-abortion guy. They would very clearly see that the justice made the ruling with terms of the drug's safety, the drug's effectiveness, the ability to get it, which is under the Comstock Act, and the capriciousness, the arbitrarity and capriciousness in which the FDA would approve or disapprove that drug. I think he ruled properly in it. It's the best when you don't have anything, when you haven't had anything to eat. Before I get into my next topic, though, I am going to do my shilling. So with that, we move to the Dragon's Treasure. For 10% off, use code Layman. Code Layman for 10% off at the Dragon's Treasure, a haven for anime and tea lovers. You can get whatever you want. You can get the merchandise. You can get teaware. You can get 5 different types of tea: white tea, green tea, oolong tea, black tea, and herbal and rooibos teas. What I was looking at just now is an herbal or rooibos. It tastes like oranges. It's got natural orange flavoring and orange peels. It is some of the best tea I have ever drank, and I have only started drinking tea very regularly. I've actually their Uncle Iroh's Legacy tea, right here. Rather, I should, right here, huh? Iroh's Legacy tastes so damn good. I wouldn't purchase any other kind of tea. Also got ceremonial grade matcha, which is a green tea. That Iroh's Legacy is also a green tea. However, the green tea, the matcha ceremonial grade, is not so much of a tea and more like a hot cocoa. It's a suspension drink. You pour it in, you whisk it up while it's into a paste, and while it's heating, while you're filling it up, you stir for 2 minutes with a full cup of water, and you get good matcha. It tasted like what I got with whenever I went to my sushi place nearby. It tastes like that, and it's great. I love it. You can also get Tea of the Month Club. Let's see what the Tea of the Month is. I guess it doesn't put it out. You can decide the frequency and whatnot. Oh god. Why I hate a complete random. Why? Chill it, son. Do they have milk tea? Oh, maybe. Maybe. I think. Let me message the guy. T-Man. What is milk tea? And do you sell it? What is milk tea and do you sell it? There we go. But yeah, code Layman for 10% off, and you can buy everything with a discount, even the merchandise and teaware. Teawares. Here we are. Good shit. I ordered this. It was supposed to come in like a couple days ago. I haven't gotten it yet. I don't know what the problem is. I'm going to... No, actually, I'm going to go check my tracking on that. See where it's at. Where's my tea maker business, tea man? No, it's basically black tea. You add milk in it, possibly some tapioca. That's 5 days out, man. You said 3 days. It's a 3-day delivery. All right, I'll get it tomorrow. Milk tea is a Southeast Asian thing. It's pretty good. What, you put... T-Man said you basically put tea in black... or milk in black tea. Is that what you're talking about? Milk tea. Like this? Tapioca. Boba tea. Brown sugar, black tea. Well, I guess he does, in part. He sells the black tea portion. Let's see what he's got. Ah, thank you. And then everything changed when the Fire Nation attacked. Alright, we got Lapsang, Shochong, Kimon, and Oolong tea. Wait, I thought this was a black tea. Why is it oolong here? Tea of Ice and Fire. Spearmint, Lapsang. I guess this is the green tea element. English breakfast. Oh my god. This man needs to set up a setting where it doesn't show, or you can like go from members to not members. Filter it out. If possible, I want to set up a non-member to member filter on the website for tea. Just an idea. There we go. I'm a rebel. I mix my tea not with a teaspoon, but with a tablespoon. This is a teaspoon for measure, I guess. I guess if you flatten it out, yeah. We now sell food-grade matcha, a cheaper alternative for various shakes, proteins, desserts. What? Hold up. I just saw this update. The green tea has an update. Food-grade matcha. Matcha. So far, I have one other new tea that'll be released in a batch with a bunch of other Dragon Wings members will know these tea. Oh yeah, if you're also interested on getting discounts, other than my 10% discount, you can go to Dragon's Wing and get yourself a membership. However, Wyvern gets you 5% off, and Drake gets you 10% off. However, with my discount, you still get 10% off, but I get 10% of the discount. Or I get a 5% of the kickback from that, which means I am actually mildly sponsored, maybe affiliated with Dragon's Treasure. What? Hello, I'm back. I need to rewatch the stream portions because I'm. Does drinking Dragon Treasure give you dragon's breath? No, but it tastes good. You'll feel like you have dragon's breath if you drink it hot enough. What was... Okay, so I go from normal stream to... Yeah, okay. OBS had a hiccup for a moment. I was a little weirded out by it. Now, I specifically want members only to be visible for others to drive out, sir. Oh, didn't think about that. My bad. I don't know. I just recently got the Dragon's Treasure affiliation by my choice recently. And I kind of feel like a dick suggesting whatever I suggest. Because it's like, I just get in and I got like a boatload of ideas that I'm putting out. It's like, you idiot. Stop talking. I feel like that's what the T-Man is thinking right now. All right, so back to the topics. It's time to hit up the Texas Shenanigans. This should be slightly shorter stories, but a lot more funny. I don't know which one I'm going to do first. We'll find out. We'll do the funny one second. A very, very bad bill. Why this Texas vaccine bill has health workers concerned. Texas Senate passed a bill Wednesday that public health advocates in the state have identified as one of the most worrisome and anti-vaccine bills being considered during the legislative session. What is the bill? What do it read? Let's find out. So the text of the bill is introduce. If it's more than like, oh, it's only 9 pages. Okay. All right, so let's read the article first, and then let's get into it. Text, Senate Bill 1024 would significantly curb the ability of state health departments, school districts, and cities and counties to require or promote vaccines of any kind. Although the bill specifically focuses on the COVID-19 vaccine, and the bill also contains provisions that could affect future vaccines that don't exist yet. Since I'm on YouTube as well right now, I just want to articulate that this is not me giving a medical opinion. This is a bill from Texas that would affect the COVID vaccine distribution. This is not my opinion on the COVID vaccine in any way, shape, or form. Please do not fucking strike my channel. Oh yeah, I should probably say that this kettle is from the Dragon's Treasure, and this strainer is from the Dragon's Treasure. It is what I've been using since day one of the streams, and it keeps me functioning, I will say. It tastes great, and the small bit of caffeine does carry me through the day. This is a very, very bad bill, said Jason Turk, a Keller pediatrician, and chair of Texas Public Health Coalition. Rekha Lakshmanan, the chief strategy officer at the Immunization Partnership, said it was a bad bill in its original form, and it continues to be a bad bill in its substituted form. The bill was written by Burnham Republican Senator Louise Kolkhorst, who is the chair of the Senate's Health and Human Services Committee. The proposed legislation is considered an omnibus vaccine and public health bill and codifies many of the executive orders Governor Abbott imposed during the pandemic, like prohibitions on cities or school districts establishing mask mandates, but also gives legislators the power to decide whether to add or remove vaccine bills or vaccines from the list of those required to attend schools in Texas. In a statement, hold on. My bad. I gotta figure something out. Okay, this was a minute 30 seconds. I got a minute and a half. Okay, so 4:47. I actually completely forgot how long I had left the tea in, so I had to go figure it out through the YouTube video. My strainer comes in the form of a 350-pound wife that likes being carried across the threshold. No, woof. That's rough. But also rough of you to say. How mean. JK, I figured. How very rude. In a statement, Kolkhorst said she filed the bill to continue the conversation in the aftermath of COVID-related vaccine policies that many Texans felt were onerous and overreaching. She said that a colleague said the bill threaded the needle of finding the balance between public health powers and our personal medical decisions. During testimony on this bill and other vaccine proposals considered by legislators, lawmakers either promoted misinformation themselves or invited witnesses who spread misinformation about the COVID-19 vaccine, vaccine experts said. Of course, vaccine experts would say otherwise. States are trying to claw back the ability of agencies to be independent and to make their own policy decisions like they normally would, White said. What do you care what White said? What about what Black said? What Senate Bill 1024 would mean for vaccine policies in Texas. Perhaps the most notable change would be how vaccines are added or removed from the list of vaccine requirements to attend schools in Texas. What includes standard shots like vaccines to protect against polio, measles, mumps, and rubella. During testimony, Colcourse noted that the recent addition to vaccine requirements were passed in 2009. Lawmakers who were directed by the Department of State of Health Services to require meningitis vaccines for students attending colleges in Texas and living on campus. The law was later updated to require meningitis vaccines for all college students, regardless of where they live. It was an action of the legislature, so this is not unprecedented, Colcourse said during the March 22nd hearing on the bill. But other changes to vaccine requirements have been instituted by Department of Health Services without a vote by lawmakers. The most recent change made to state requirements was an update to make the measles, mumps, and rubella vaccine required for all grades from kindergarten through 12th grade in the 2016 to 2017 school year. According to the spokesman for the state health department, previously those changes had been rolling out year by year. A vaccine advocate says completely giving that authority to the lawmakers would leave public health decisions to the legislator with no background in vaccines or preventative health care. I mean, wasn't that case with Fauci? You're shifting primary decision-making authority away from healthcare professionals and the public health experts when it comes to setting future immunization requirements. Lakshmanan and advocates in Texas said, and you're putting that in the hands of the legislator and policymakers, which is troubling and short-sighted. Well, I mean, yeah, but it's proper still. Short-sighted as it may be to give the healthcare decisions to the legislatures, you could either remove the legislators from the process by making constitutional amendments that would paint the ability in one light or another, or you could get behind the idea that the legislatures are who the public health matters should go to anyway. Like, it's up to the people. The problem with this whole argument against it is that it's basically just the people who have public health matters in mind, like doctors and whatnot, who can make policies in this matter, are not elected officials. The voice of the people say, we want the legislatures to make the decision on this matter. The voice of the people should be heard. And dissatisfied or displeased as healthcare professionals might be, it's not up to them. It's up to the people. Oh, fuck. You're shifting the primary decision-making authority. I read that. In Texas, children who attend schools don't have to get vaccinated if they have a medical or conscientious exception to vaccines. The COVID-19 vaccine is not required to attend school in Texas. Colcourse bill explicitly prohibits the COVID vaccine from being added to the school and vaccine requirements. Testimony in the state capitol. Vaccine experts also said in the testimony in support of the bill was alarming because of the medical misinformation that was repeated in support of it. During testimony in March 22nd, Dr. Robert Malone, a medical medical doctor licensed to practice in Maryland, was featured as an invited witness, and lawmaker deferred to him, an expert on COVID vaccines and other immunization policies. I want to reiterate to YouTube, the bitches, that this is not my opinion, and I would say this is not me giving medical advice or opinions. This is the testimony of a person who was talking in regards to the COVID-19 vaccine. Do not strike my channel for this. Malone says he invented mRNA vaccine in his work decades ago, a co-author of one of the Malone's papers on RNA, and told the New York Times that was a total false claim. He became prominent during the pandemic and appeared on radio and television shows at rallies and state house campaigns against COVID-19 vaccinations. In a statement, Colcore said Malone was given priority as a witness due to his national prominence and travel schedule, which is commonly given to similarly credentialed witnesses. Bitches better recognize. In 2021, Malone appeared on an episode of the Joe Rogan Experience podcast, during which he said that the U.S. are trapped in mass formation psychosis, in which anyone who questions the narrative on COVID-19 is attacked during the episode. He said, in the situation that the United States was comparable to that of Nazi Germany in the 1920s, more than 200 healthcare workers signed an open letter criticizing Malone's statement as promoting false and societal harm assertions. I mean, it's not wrong if it's got some kernel of truth and some validity to it. On his website, Malone prominently features an endorsement of Robert F. Kennedy Jr., who has been spreading incorrect information about vaccines since 2005. Kennedy, the nephew of President John F. Kennedy, first began promoting the widely discredited idea that childhood vaccines can cause autism, a notion that has been repeatedly proven false. Kennedy was identified as one of the Disinformation Dozen by research group, identified the top 12 purveyors of false information about COVID-19 vaccines online. Because of course they would slap him with a disinformation label. Why wouldn't they? It's in their interest to basically lambaste him. I'm now realizing something about the logo for the Dragon's Treasure at the bottom bottom left hand of the screen, and I'll fix that whenever I'm done with the stream. Or maybe right now. We'll see how fast this document can load. Kennedy praised Malone as the most important prophet for medical freedom, public health, and civil rights, according to Malone's website. Malone did not respond to emails requesting comment. A Star Telegram reporter called a phone number listed on this website, but did not receive a return call. On his blog, Malone wrote that he was asked to testify by Rebecca Hardy, the policy director of the Keller Group Texans of Vaccine Choice, which frequently testifies in Austin. Alright, just gotta make a new pixel layer. put it underneath the background. Sorry, I'm doing that thing that I said I wasn't probably gonna do. Right here, haha, haha. Stretch up. I don't know. 1/500 by 1/500. The fill is pure white. Alright, and I'm going to save this as... No, export it as PNG, and you're about to see everything change. So if I just go back to the scene... Yep, there it is. Limb bastards. There we go. I fixed the issue live on stream. I don't know why I do that. One active Texas physician testified in support of the bill, and second physician registered in support as well. According to the minutes from the March 2nd or 22nd hearing, Malone is licensed to practice in Maryland. Other people who testified in support include Dr. Richard Fleming, a cardiologist whose Texas medical license expired in 2005. According to the Texas Medical Board in 2009, Fleming pleaded guilty to felony charges of medical health care and mail fraud in Nebraska. Fleming later told the Food and Drug Administration that he was innocent, despite pleading guilty. One man, Brian Artis, identified himself as a doctor who works in Plano, although the Texas Medical Board shows that no one of that name is a licensed doctor in Texas. Anti-vaccine legislators and their supporters alike testified that COVID-19 was poorly researched and that it caused injury and even deaths to people who received the shot or shots. But researchers who study COVID-19 vaccines say the opposite is true. Because so many people around the world have been vaccinated against COVID-19, it's actually one of the most researched vaccines in use today. I don't think any vaccine in the world has been scrutinized as carefully for safety as the COVID vaccine, says Dr. Kawasar Talat, an assistant professor at the Johns Hopkins Bloomberg School of Public Health. Talat also said the co-director and clinical research at the school's institution for vaccine safety. Legal, I'm gonna run. I'll check with you later. Incognito. Take care, man. Thanks for coming. Oh, yeah, if you like what you're seeing so far, please subscribe. Dr. William Schaffner, professor of preventative medicine and infectious disease at Vanderbilt University School of Medicine, said there is no doubt that COVID vaccine is now one of the best studied vaccines we use globally around the world. As with all vaccine drugs and medical treatments, nothing is completely free of risk. Schaffner noted even drugs as common as ibuprofen can cause injury to certain people. But in general, the risk from COVID-19 vaccines are rare adverse events, he said. Although the bill has passed out of committee, that doesn't necessarily mean it'll become law. Senate Bill 1024 will have to be approved by the entire Senate twice before it can be referred to the Texas House. You know, I kind of miss the... I used to use StreamYard or Streamlabs before I went to OBS. But I kind of miss the, like, view count that I would get from, like, YouTube or Twitch. That's displayed on the setup. Maybe there's an extension for that. That is the first Texas Shenanigans thing. You ready for the second? Oh, wait. We gotta read the bill first. Except as provided, so this is to be entitled by Colkhorst, relating to preventative health care and public health, authorizing a civil penalty. Except as provided by subsection C, each disease listed in section 16104, Health and Safety Code. They removed each from this. Each student shall be fully immunized against, or it now reads, except as provided, each student shall be fully immunized against the disease listed on section 16104 Health and Safety Code, and it removes shall be immunized against diphtheria, rubiola, I guess, mumps, tetanus, and poliomyelitis, except as provided by section or subsection C. And it reads, each year the Department of State Health Services shall prepare a list of immunization requirements for admission to public schools. The department shall prepare the list in English and Spanish under the section and any additional immunization departments. So the added language is, an elementary or secondary school may not require a student as condition of the student's admission to or continue enrollment in the school to be vaccinated against the 2019 novel coronavirus disease, COVID-19. The immunization required for admission to public school in accordance with Section 3801 and health clinics in the district that offer influenza vaccine to the extent those clinics are known to the district by rules of the Department of State and Health Services adopted under section any immunization or vaccine recommended for public. So it's kind of removing the Department of State and Health Services. I'll link to the page on Department of State Health Services website that provides where any person may obtain. Provides information relating to procedures for claiming an exemption from the immunization requirements. Section 91921. Prohibition on private or independent institutions of higher education mandating COVID-19 vaccinations for students. COVID-19 means coronavirus disease. Private independent institution means section 6103. A private or independent institution or higher education may not require a student as a condition to the student's admission to the continued enrollment in the institution to be vaccinated against COVID-19. A student at an institution of higher education who is pursuing a course of study in a human or health profession to be immunized, the executive commissioner may require a student to be immunized against diseases listed and against hepatitis B, measles, rabies, and varicella. As applicable, the executive commissioner may require those immunizations for any students. The additional disease for students of higher education who basically strikes out this from above and moves it up. A requirement under subsection B for a student to be immunized against hepatitis B may apply only to students who are enrolled in a course of study that involves potential exposure to human or animal bodily blood or bodily fluids. An institution of higher education may not require a student as a condition of the student's admission. So it's COVID-19. Oh, fuck. The executive commissioner may recommend to the legislature immunization to include on the list of immunization requirements for children under subsection 161.04. Every child in the state shall be immunized against diphtheria, hepatitis A, B, measles, meningococcal disease, mumps, pertussis, polio, rubella, tetanus, and varicella, in accordance with the immunization schedule prescribed in the department rules. The executive commissioner may not require immunization against any additional diseases for students admitted to public or private primary or secondary education. So right now it's a suggestion. Oh my god, I'm so sorry. Adverse events reporting system for vaccine and booster doses. The section healthcare practitioners means, yeah, it's just going to define them. Department shall establish and maintain a department internet website policy or publicly accessing reporting system to track adverse events following the administration of a vaccine or booster dose. That the vaccine reporting must enable healthcare practitioners and other individuals to submit information in accordance with the subsection, be maintained separately from the immunization registry or any other statewide registry for tracking immunization information. A healthcare practitioner who administers a vaccine or booster dose that the vaccine to a patient shall submit to the reporting system information on any adverse events the patient experiences following the administration of the vaccine or booster dose, regardless of whether or not the booster dose caused the adverse effect or event. An individual who obtains a vaccine or booster dose of the vaccine may report to the reporting system information on any adverse event the individual experiences following the administration of the vaccine or booster dose, regardless of whether the vaccine or booster caused the adverse event. The appropriate licensing authority may impose disciplinary action, including an administrative penalty, on a healthcare practitioner who violates a section in the same manner and uses the same procedure to authorize uses to impose disciplinary action on a healthcare practitioner who violates as the authority licensing or regulatory laws or rules. The executive commissioner shall adopt rules necessary to implement this section, including rules to ensure that information accessible through the reporting system does not disclose personally identifying information that is confidential under state and federal law. Prohibition on political subdivision mandating COVID-19 vaccinations. Notwithstanding any other law, including Chapter 81 of this code, Chapter 418, Government Code, a political subdivision of the state may not issue an order, adopt on insurance, or otherwise require an individual to be vaccinated against COVID-19. Prohibition of unmandated preventative care. Prohibition on face mask requirements. A government entity or private entity that accepts any state money may not require a person to wear face mask or covering to prevent the spread of communicable diseases. Texas Education Agency shall adopt rules to prohibit a private or public elementary or private or public primary or secondary school from requiring a student, teacher, or other employee, underschool employee, parent, or visitor to wear a face mask or covering to prevent the spread of communicable diseases. Civil penalties. Government entity of private entity that violates 161.701 is subject to civil penalty and an amount to not exceed $2,000 per day for each violation. The Attorney General may sue to collect the penalty under this section and may recover reasonable expenses incurred in collecting that penalty, including court costs, reasonable attorney's fees, investigative costs, witness fees, and deposition costs. Sovereign and governmental immunity to suit is waived and abolished to the extent of liability created by the section. Healthcare facilities is definitions. Patients' rights. Prohibits discrimination based on vaccination status. A healthcare facility may not refuse to provide healthcare services to an individual based on the individual's vaccination status or post-transmissionary recovery of a communicable disease. Medicaid reimbursement prohibition may not provide Medicaid reimbursement to a healthcare facility that violates this chapter and shall not disenroll the facility from participation as a Medicare inviter. Discrimination against based on vaccine status. An employer commits an unlawful employment practice if the employer fails or refuses to hire, discharge, or otherwise discriminates against an individual with respect to the compensation or terms, condition, privileges of employment because the individual has not been vaccinated against COVID-19. The labor organization commits an unlawful employment practice if the labor organization excludes or expels from membership, otherwise discriminates against an individual because the individual has not been vaccinated against COVID-19. An employment agency commits an unlawful employment practice if the employment agency classifies, refers for employment, fails, or refuses to refer employment, or otherwise discriminates against an individual because the individual has not been vaccinated against COVID-19. So COVID rules and laws. Hold up, I gotta take a moment to, stand up, stretch. So, be right back. I'll keep the mic on so you can still hear me. Because I'm only gonna be standing up and walking around for a minute. It's not like I'm gone. Yeesh. I need to get a better chair. Let's start a chair fund. Alright, so I got, I think, 2 more topics for the day. And it's my Friday, actually. I should probably do like a TGIF thing. Sorry, just checking my teeth. My smile isn't offensive on camera. Holy shit. That's great. The next topic for the stream is going to be last of the Texas Shenanigans. Texas teen dies rock climbing. 2 hours later, he revives. A literal miracle. A teen's doctor describes not only reviving, but doing so with such a little damage as a literal miracle. Okay, thank God, it's a short story. Sammy Burko, a teenager from Missouri City, Texas, went to a rock climbing gym where he suffered a cardiac arrest and died. 2 hours later, he was alive. He climbed to the top of the wall, rang the bell, and as we were told, and then his body went limp. It looked like he was either playing around or passed out. They weren't quite sure, and then when they realized he was unresponsive, they lowered him slowly. Jennifer Burko, Sammy's mother, told Houston Fox 2026. Paramedics and doctors proceeded to administer CPR for 2 hours before informing Jennifer that he's gone. She and her husband Craig sat with their son for a few minutes to say their goodbyes. Mother passed COVID to babies through placenta, possibly causing brain damage. What the shit? I started talking to him, just telling him how much I love him, sorry that we didn't know how to save him. Suddenly, as I started praying, my husband said, "Oh my gosh, he's moving," said Jennifer to the local news station. The couple shouted for the medical team, who raced back in and began administering aid. Due to how long Sammy went without oxygen, there was fear of he suffered a major brain injury. However, aside from a physical injury, he has so far only experienced short-term memory loss. I don't remember anything about that day, about the day it happened. Last thing I remember is the night before we had to sign waivers online for rock climbing, and then I woke up not even in the pediatric ICU, Sammy told Fox 26. I woke up in the transitional ICU, and the first thing I remember, then I remember my dad telling me, "This is what happened to you. This is what happened, and you better remember this time," because he said it so many times. Good God. This was of this year, of this month, yesterday, or at least reported yesterday. Despite how lucky Sammy was, that does not mean the road to recovery has been easy. Sammy's been recovering strength. He's working to recover his strength in his legs after a month in the hospital, and is undergoing physical therapy for the ischemic spine injury. I was very struck by his story. It was very gripping and very unusual. The only young man you know who has a catecholaminergic polymorphic ventricular tachycardia. Catecholaminergic. Wait, why was that so hard? Catecholaminergic. Polymorphic ventricular tachycardia, which is a super rare genetic disorder that affects his heart. Dr. Stacy Hall, medical director of pediatric rehabilitation program at TIRR Memorial, Herman told Fox 26. We do see kids all the time here who have had CPR, but with very prolonged CPR, we typically see severe global anoxic brain injuries. So to me, he's a literal miracle. The Burkos are currently preparing their home to accommodate Sammy's wheelchair. I know it would be weird, crazy experience learning to walk again and working on strength without using my legs to be able to balance me. It's just been an amazing experience here, actually. Like, I've noticed that I'm better every day. I'm doing something new every single day, Sammy told the local station. The tragedy also shed some light on past tragedy, as 3 years prior, the Burkos lost their son, Frankie, to what they now know is the same genetic mutation that almost killed Sammy. He and his mother underwent testing and are currently taking medication to help prevent any future situations or issues. Catecholaminergic polymorphic ventricular tachycardia. Sudden rhythm changes, disturbances, arrhythmias, and otherwise healthy children. So yeah, as it shows here, this is a normal sinus rhythm. PQRST. I don't know which portions of these are which, but this is a QRST wave. I don't know how to read any of this. This is when it starts going out of whack. This is the initial slope. This is that slight dip. This is the spike, back down to up, and then this. And then it repeats. You actually get a sign before ventricular tachycardia. One, two. So in this case, this part's the part that doesn't pump so well. Yeah, as it says, this is the ventricle. So that's where it affects. That's the weird Texas Shenanigans. Let me see about the extra story that I might have done. I don't... Wait a minute. Fuck! Sorry about that. Here's the Fox story about the teen dies rock climbing 2 hours later, revived. Here's Sammy. Sammy Burko died for 2 hours while rock climbing and revived. Apparent miracle. So here are the QRST waves. Here's what I was talking about with the hump, the dip, the spike, dip back down, and then the secondary hump. And then it just goes wild. This is a beat that cannot sustain heart or cannot sustain blood flow and health. And this shows a diagram where it affects the ventricle. This is the ventricle, and this is, I believe, the aorta, if I remember my biology right. Atrium. Now, the aorta is up here. This is the atrium, and this is the ventricle. I did not remember my biology right. I'm sorry. So let me go back to the camera, see if I want to actually touch on the story if it's long, if it's lengthy. I'll cover it tomorrow. I'll actually have it listed as a title. We're going to move on to the IRS issue and have fun with it. All right, here we are. Tax court rules IRS does not have statutory authority to assess penalties for failure to file a Form 5471. Every now and again, a case comes across your desk that makes you say, whoa. Alon Vare versus Commissioner is just such a case. The U.S. tax court gave Vare a win, ruling that the IRS could not collect from him in this instance. The IRS had no statutory authority to assess penalties under Section 6038. Facts. For the tax years through 2003 to 2010, Alon Vare owned 100% of Catum Capital Incorporation, a foreign corporation incorporated in Belize for the tax years of 2005 to 2010. Vare was a 100% owner of the Morningstar Ventures Incorporation, another foreign corporation incorporated in Belize. God damn, this typing. For the years at issue, Vare had reporting requirement under Section 6038A to report his ownership interest in Catum Capital and Morningstar Ventures. The requirement generally means that taxpayers must Kelly Phillips Herb, your typing was not fucking checked at all. The here and the facts section, and requires taxpayers must file or much file Form 5471 information returns of U.S. persons with respect to certain foreign corporations to disclose an interest or ownership in a foreign company if a taxpayer does not meet this requirement. Sections 308B provides for penalties beginning at 10% or $10,000 per year. Vare did not report. The court noted that the failure was done willfully, and so the IRS passed penalties under Section 6038B1 of $10,000 each year. The IRS later assessed continuation penalties under Sections B2 totaling $5,000 or $50,000 for each year at issue. The continuation penalty is $10,000 for each 30 days the taxpayer does not comply after the initial 90-day notice period, subject to a maximum of $50,000. When Vare didn't pay, the IRS attempted to levy his assets. Vare didn't dispute that he did not file, nor that he did not pay. Instead, he challenged whether the IRS had legal authority to assess Sections 6038 penalties. Another code section is important here, Section 6201. Authorizes and requires a Secretary of Treasury to make assessments of all taxes, including interest, additional amounts, additionals to taxes, or What the fuck? All taxes, including interest, additional amounts, additions to taxes, and assessable penalties. The Secretary delegates these duties to the IRS. Here's where the words matter. The IRS contended that the terms assessable penalties include any penalties found in the code that are not subject to the code's deficiency procedures. The IRS also argued that taxes in Section 6201 is broad enough to include Section 6038 penalties. They further claimed that the legislative history supported this position. The court disagreed. Hey, Southern anarchist, what's up, Mr. Poopy Butthole 69? How's the streaming right now? No stutters, no hiccups, no crashes? I've been streaming for 2 hours and I have not had a problem. Thank God. Sup, homie? Headed to the gym? Hell yeah. Get that workout going. I'm on like day 4, I think, day 3 of chicken and rice meals. I'm probably going to change it up with like a lean beef and beans later. Good so far, but I just got here. That is true. Dude, the IRS ate shit. They wanted to penalize a U.S. citizen for foreign affairs, and they got told to kick rocks. It is important to understand the distinction at play here when a tax including an additional amount, addition to tax, a simple payment, penalty, or interest, is assessed. The IRS may take certain actions to collect the tax administratively. That's clear from the statute. That can include levies as well as attempted here, as was attempted here. Findings. The terms assessable penalties is key. The tax court agreed that assessable penalties is, as used under Section 6201A, is not limited to penalties found in subchapter B or of Chapter 68 of subtitle F. Holy God! These things, reading them wins me. Actually titled Assemble Penalties. But that does not mean the court said that it does not automatically apply to all penalties in the code not subject to deficiency procedures. In other words, assemble penalties is not a term used to distinguish between penalties subject to deficiency procedures and those that are not. Furthermore, the tax court found that Congress explicitly authorized assessment for myriad penalties provisions in the code, citing among other things penalties under sections 6671 and 6725. 6671 through 6725. It's dense for reasons they don't want everyone to understand it. Yep, that is probably true. I just didn't think reading would be such a fucking stress on my lungs in the way that it has been right now. Ugh. And sections 6651 through 6751. But not for section 6038B penalties. The question then wasn't whether the penalties were included in the statute. They are, but whether the IRS can assess and collect these penalties by administrative means. The tax court didn't buy the IRS's argument that it has the authority to levy those penalties systematically, nor that the agency did not take additional steps such as civil litigation to collect. Simply put, the court wrote, while Section 6038B provides for penalties, it does not provide for assessable penalties. The court further noted it was loath to disturb this well-established statutory framework by inferring the power to administratively assess and collect the section 30. Fuck. The key is deep breaths when you pause and keeping a measured pace. I've been doing that lately, but hold on. But man, this is like singing. This is like choir. Penalties from Congress did not see fit to grant the power to the Secretary of Treasury, expressly as it did for the other penalties in the code. Moving forward, that means that while the government may not be able to collect liabilities for these penalties through civil actions under 2461A, the IRS may not assess or administratively collect these penalties. See, the problem is, I would have thought that an article was written in a way that you could read it, where the periods are in place, are where you would actually be able to breathe. But it seems like it's not. The IRS may not assess or administratively collect these penalties. It is important, as the court made clear, that the holdings are here concern only the applicable manner of collection for sections 6038B penalties. This does not mean that the taxpayer does not have an obligation to file Form 5471 or any other form. Again, this is focused on procedure and collection. FAR may have won in tax court, but the matter is not fully resolved for other taxpayers. It is unclear whether the IRS will appeal. I will expect them to do too. It is unclear whether how long that may take. It's also not certain how the ruling could impact taxpayers otherwise subject to Section 6038. We'll likely see this issue or related issues back in court soon. With that, we're done. I don't know why I relax so much on the stream. I don't. These people suck. So before I wrap off the stream, to anybody who's still here, go to the Dragon's Treasure and order tea or merchandise with code Layman for 10% off. The Dragon's Treasure is a haven for anime and tea lovers, guys. If you like anime, you'll appreciate the way the Dragon's Treasure, the Tea Man, has labeled some of these tea. And also the tea itself is just very good. You ever look into the Podestas brothers? Not really. I'll probably look into them another time. Yesterday was weird. I was trying to get through the stream with it fucking bitching out every so often. And that annoyed me to a point where I was just like, done with the day. I'll look into them sometime. They killed someone, right? Or it led to their death. But yeah, Dragon's Treasure, a haven for anime and tea lovers. Use code Layman for 10% off. And here's why you should use code Layman. It is next to the best discount policy that you can get. I mean, it's just me personally. I don't know about that stream about it. I went to work basically right after that. No, I didn't go to work. I streamed with Gosney. I went to work, came home, started my new chicken diet, and then basically wanted to die yesterday because my body felt lethargic as shit. But yeah, 10% off with code Layman, and here's why it's the best that you use it. Wyvern gets you 5% off all orders. Drake gets you 10% off of all orders. But Dragon's Treasure or Dragon Tier gets you 10% off, and I get 5% of the kickbacks. So yes, this is a financial interest in this group. If I sell to you, I get the money. But as I also shown, it doesn't compete with the Drake discount. You could also get your own Dragon's Wing discount or Dragon Wings membership, but that's per month and per year. This is free. I'm offering you a free discount on everything. Get the utility and ingenuity teapot strainer and teapot kettle, and all kinds of different tea that you can get from this. White tea, green tea, oolong, black, and herbal and rooibos. Oh, and if you're into the green tea, Dragon's Treasure, or the Tea Man, recently just put up the matcha food grade, or the food grade matcha, which is cheaper than the ceremonial grade, as you can see. It probably tastes just as good. This is probably the type of matcha I'm familiar with, as opposed to the ceremonial grade, because the food grade has, I think, was served with that sushi restaurant I went to normally. Made for all tasty treats. I guess the difference is that it's grown and made with the finest gyokuro leaves. The ceremonial grade matcha is the choice for those that have a full taste and experience of one of the most famous teas around. So yes, remember, code Layman at checkout for 10% off. And with that, I think I am done with everything, or with the stream at least. Those are all the topics. I will cover... What's his name? I gotta figure out his name. The Josh Alexander ordeal in Canada. Josh Alexander is that kid in Canada who protested against the transgender thing, or transgender agenda in Canada, and was arrested for the protest in Canada. You know, good old civil liberties in Canada. No one will ever violate them. No one will ever kill you in Canada for any reason at all. The state has sanctions to kill you, and the people have no right to protest. What a great country that is. But yeah, that's the stream. Thank you for everybody who's shown up. Thank you for everybody who will watch on the replay. I'll definitely try to figure out what I'm going to do tomorrow. I'll probably hit up that Canada topic. And whatever other news pops up, I'm trying to think about what might pop up, but I'm not able to. Oh, January 6th? I can do that. Can't say I'll be good at covering it. It'll be I think Robert Gouveia does a better job at it, but I'll try. Yeah, I could probably do that. The deprivation of civil liberties. Yeah, dude, I'm gonna probably do that as well. I just found a topic right now. A topic for tomorrow definitely will pop up as Twitter policy against dead naming transgender people. That's definitely going to be for tomorrow's stream. So, with all that, thank you for watching. Thank you to anybody who showed up to watch. I greatly appreciate the support. Hopefully, I'll be able to stream tomorrow at the same time. At the time I hopefully want to stream, I'll probably try to get my work done very quickly. It's my day off. No, wait. No stream tomorrow. No stream. I'll have to stream on Thursday. I need to go help someone out. I have a real life obligation. If I can. So no stream tomorrow, but I will cover what I was going to cover tonight or tomorrow on Thursday. I will hog my room. I'll hog the room from my roommate. Make him endure not so acclimate weather. But yeah, thank you for coming. Hopefully you enjoyed. And I will see you next time.